This is on the California Coastal Commission. I've been reading about them in the news the last few months. And ex parte communications. Senator Jackson.
Thank you, Madam Chair and members, and thank you, Senator Allen. My witness has to catch a plane at some point, and with the uncertainties of some of the discussion, I appreciate your giving us priority here. The recent firing of the executive director of the Coastal Commission has resulted in a rather high degree of public concern and public uncertainty, accusations of a lack of transparency in the decision-making process, and concerns of undue political influence by commissioners in dealing with commission staff. SB 1190 is designed to help restore the public's trust in the Commission, ensure that decisions made by the Commission are more transparent, and remove the possibility and perception of backroom decision-making. This needs to be government at its best, with the sunshine as clearly directed as possible on the work of this very important but sometimes controversial commission. SB 1190 will do this by banning ex parte communications between interested parties and commissioners at the California Coastal Commission, and by codifying the independence of the commission itself. In matters before the Commission, ex parte communications are defined as any private, oral, or written communications between a decision maker and an interested party that do not occur in a public meeting. The California Supreme Court has found that ex parte communications are a violation of due process because they can bias decision makers in adjudicative government actions by allowing one party to influence a decision maker outside the presence of other parties and off the record. As such, although current law allows ex parte communications with commissioners, it does require that such communications be disclosed on a form, or if they occurred 7 days prior to a meeting, verbally in a public meeting. But unfortunately, these requirements are insufficient to address due process concerns in the Coastal Commission context for two main reasons. First, commissioners' disclosures can often be, and often are, rather cursory and lack details that provide other commissioners, staff, or other interested parties to a matter, and the public, with adequate notice and the opportunity to respond to issues or requests that were raised during the ex parte communication. Second, there is no requirement that commissioners must meet with all parties that have requested ex parte communications, and some interested parties have complained in the past that their ex parte requests were completely ignored or refused, leaving them without equal opportunity or equal time to make their case. SB 1190 would address these two shortcomings by banning ex parte communications. Ex parte communications, in fact, restrictions rather on ex parte communications are common for other judicial and quasi-judicial bodies, for example, from courts to state agencies. When acting like judges, which is what the commissioners frequently do, decision makers need to be impartial and open-minded, considering the input of all interested parties equally. For example, a judge in a criminal case doesn't typically get to question defendants or plaintiffs prior to a hearing, and certainly never on a golf course or at a restaurant. If a conversation happens at all, it happens on the record, in the court, and through official court filings. It is important to point out that there are 12 voting commissioners, each with their own viewpoints. SB 1190 will not stop commissioners from being free to express those views and to vote in alignment with those views. The other important aspect of SB 1190 is the provision to clarify that commissioners may not attempt to influence commission staff findings or recommendations on matters before the Commission prior to a public hearing. And independent staff is critical to the objectivity and the ability to fairly analyze matters, develop the public record, and craft recommendations for consistent application of the law without undue political influence. Decision makers are free to question staff findings and recommendations and to disagree with staff, but it has to take place in the context of a public hearing. And finally, I must say I am somewhat disappointed, although not totally surprised, by the apparent late opposition to this bill. Dropping an opposed letter less than 24 hours before the hearing, as we know, is inappropriate, but actually is reflective of why this bill is necessary, in order to avoid the heavy-handedness that we see when interested parties, particularly those with all the financial wherewithal to have lobbyists and others be able to engage decision makers in the dark. And frankly, the opposition, I think, demonstrates why there is a need for this bill. We know, though, that groups with a mere fraction of the resources that some of the opposition has were able to contact my office, ask for a fact sheet, have conversations with staff, and send in on-time support letters. And I would indicate that this matter has been on the file for several weeks. The opportunity, I have made all efforts to open my office to all points of view, including those of the opposition. The fact that they failed to come to my office to have these conversations is a cause, frankly, of grave concern to me and disappointment as well. So I thank you, respectfully request your aye vote, and have with me here today a former Coastal Commissioner, someone who has been a strong advocate for the coast and the work of the Coastal Commission, Sarah Wan.
And one of my constituents.
And a constituent of the chair. Totally accidental, of course.
Thank you, Madam Chair. Sarah Wan on behalf of the Western Alliance for Nature. I'm going to give you a short background so you understand why I think this is an incredibly important bill to support. In the 80s and 90s, I was a coastal activist that regularly appeared at the Coastal Commission hearings. Then in 1996, I was appointed to the Commission and served as a commissioner for almost 15 years. Since then, I've been a paid agent representing clients at the Coastal Commission and doing ex partes on their behalf. I therefore know this from every side, and I can assure you there is nothing fair about this process. There is no way for the public to compete with paid professional agents, and that includes me. This bill will go a long way towards removing the obvious bias that results. The Commission is a quasi-judicial body which makes ex parte wrong. Commissioners are supposed to go to a hearing and act as judges to determine if the development or the LCP proposed is consistent with the Coastal Act. That's it. That's what their job is. The current ex parte situation is totally one-sided. There's no way for the public to compete with paid agents. These agents attend all the hearings, travel up and down the coast to meet with commissioners, and socialize with them. Some members of the public may have the ability to occasionally talk with commissioners, but most cannot. Their attempts to get ex parte meetings are frequently ignored. Even when activists get an opportunity to speak with some commissioners, they can't usually meet in person, can't go to every meeting or socialize, and they are therefore at a disadvantage. Those opposing the bill are those who can afford to pay agents. They are the ones who are opposing this. This is not about this bill is not about preventing development. This is about upholding existing law. No matter what the Chamber and its supporters would have you believe, almost all development gets approved because the Coastal Act does not prevent development. It simply requires that it be consistent with the state's long-term objectives of sustainability. If no one can talk to commissioners in advance, it does not mean that there will be no input from all sides. It is that the input must be in writing and available for all to see. And commissioners will be forced to come to the hearing with an open mind, read the staff report and correspondence, and listen to the testimony, and then do their job as judges. The second part of the bill is equally important. It deals with the independence of the staff. Clearly, one of the major reasons the executive director was fired. Charles Lester continued the tradition of allowing staff to provide their uncaptured professional and scientific advice and recommendations. That is what has made the Coastal Commission so unique and so important towards ensuring that development that proceeds is made consistent with the law. Unfortunately, if this bill is not passed, I believe that staff's independence will be jeopardized, and so will the future of the coast. Thank you.
Yeah. other people here today wish to add their name on in support of this measure?
Amy Trainer, excuse me, Amy Trainer with the California Coastal Protection Network and support.
Anyone else adding their name in support? Anyone in opposition?
Valerie Nara for the California Chamber of Commerce, and the very first thing I want to do is turn it on.
It's on, yeah, just get closer to it. That one mic has been,
A little off.
yeah, it's good. That's good. Thank you.
My very first thing I want to do is I want to apologize to Senator Jackson for not coming in and speaking with her before I dropped the letter. My apologies, I was wrong. Onward. This bill bans all ex parte communications between the commission and interested parties. But, the commission is a public body and should be encouraging citizen participation and communication. Commissioners who want more information should be allowed to ask for it, and they should also be required to disclose it and describe it publicly. Although the bill allows interested parties to talk to staff, it is not the staff, but it is the commissioners who make the ultimate policies. So discourse should be free between them, interested parties, and the commission. Limiting the commission's ability to communicate openly with its own staff, I think, cripples the function of the commission. Staff provides necessary knowledge, expertise, and technical understanding to the commissioners. And we view the commission's role as to analyze and make decisions based on a comprehensive review of information from both sides and from staff and other parties. And we don't believe that happens if SB 1190 passes.
Thank you.
Tom Scott, I'm the State Director for the National Federation of Independent Business. I would say that, we are fully supportive of the issue of transparency, disclosure, and public participation. So, and we're certainly on record relative to that on numerous issues. But what's concerning to me is that this is sort of a blatant attempt to hamstring the Coastal Commission by requiring all discussions on commission matters to be at public hearings. Commissioners are currently free to communicate with anyone on issues to get important background information. They must currently disclose and describe any communication that's required by law. I mean, we don't even require this of legislators. It is critical for the public to have real access to commissioners and for commissioners to get critical information before they vote. And just to clarify, I mean, NFIB does not have agents before the Coastal Commission. We could not afford that kind of issue. But I'd also say, just as a person, I'm on a planning commission for a city, and I don't want to compare the City of Folsom's planning commission to the powerful Coastal Commission. But I find ex parte communication very helpful. And I'm open to anybody who wants to talk, email me and we do have multi-million-dollar issues, even with my city. But to bar me or ban me or make this a lot more awkward just seems to me like, look, I get it. There was a particular situation with the Coastal Commission. This just seems to be what I feel is an extreme overreach and a cutout when you're not really holding anybody else to that same standard. You're just sort of carving out the Coastal Commission. But as a planning commissioner, it would really inhibit my ability to do my job as an appointee. So with that.
I just note for the record, as a former Coastal Commissioner, a former City Council member, now a legislator, the only body that's quasi-judicial among those three is the Coastal Commission.
Yeah.
They're supposed to act as judges. They determine consistency with the Coastal Act. It's sort of it's a directed thing. So, so as a city council member, I always met with people, but at City Hall with staff and things. But we weren't, by law, designated as a quasi-judicial body, and that's a specific nuance and why there's a difference. So this doesn't affect
Yeah.
Folsom, it doesn't affect the legislature, but it's because it's quasi-judicial. That means like a judge. You don't have judges having meetings on the side with everyone else, generally speaking, unless it's a settlement. So that's just a FYI. Anyway, let's see if there's anyone else in opposition that would like to add on their name in support.
Morning, Alyssa Stinson on behalf of the California Building Industry Association, also in opposition.
Okay, the EIA is opposed, and you have letters in, do they?
They're on the coalition letter that we got.
The coalition letter, very good. All right. Okay, and no one else opposing the bill? Let's open it up for members' questions or comments. Yes, Senator Wolf?
I'll be glad to move the bill. I wanted to say, I want to thank the author for doing this. I think you have a, this is not an easy bill to take forward. I have spent several years looking at the Board of Equalization when I was chair of Governance and Finance, which is in fact acts as a judicial body over tax appeals. Millions of dollars are involved, and ex parte communications are permitted. That is a travesty. And despite efforts to change that in the 7th largest economy in the world, we haven't been able to do that. I wish you well. I appreciate the fact that Sarah and Sierra Club and others who have, engaged in the process and got their 2 cents in the door at times as well, are supporting the bill. It is good government, it is appropriate, and we ought to be about this. So be glad to move the bill.
Thank you.
I just had a question for clarification purposes, to make sure I remember this correctly. When I stopped having any ex parte communications because it wasn't fair that only some people could drive out to reach me and others couldn't, and it was better to wait till you had the staff report. But when you get the big staff report in the mail, in a box, no pictures, I mean, it's 10-point font, don't they include letters of opposition or support?
Yes, they do.
That's my point. I wanted to make sure I remembered that correctly. And so,
If they get them in on time.
yes, they get them in on time, which you get them, what, a week before?
Yeah, sometimes, unfortunately, the amount of time is so short that people don't get them in, but
Yes.
yeah.
If they get
them in on time, they're there.
Otherwise, they're stacked up at our dais where we're sitting that day, which is never a good thing to do. It's always good to read it in time. So the communication by putting it in writing, coupled with the staff report and the pile of information that you get to weed through, that takes care of all the ex parte communications because staff has had it, everyone has equal access to it. So I would encourage by default getting back to those letter writing skills that are incredibly important for the record as well. So it doesn't shut off all communication that you need to have with people. It just makes it technically legal and unbiased, and it's a little more fair process. Yes. Oh, wait.
And the importance of that is that when it's there in writing, the entire communication is on record. When it comes through ex parte communication, you do not ever get to see what the entire discussion was.
So all the other interested parties have access to that. All right. I just wanted to state that for the record. So there was a motion by Senator Woke. Would you like to close, Senator Jackson?
Very briefly, just to confirm and to agree with Senator Wolk that this is a good governance bill. We need to reestablish confidence that the work that's being done on behalf of the people of the state is being done in a fair and impartial way with as much transparency as is possible. And this bill actually aligns the Coastal Commission with other boards and commissions that do not permit ex parte communications. So I just want to stress this bill is not precedent setting. This kind of ban exists at other commissions and boards, and actually, it isn't even the first time we've attempted this. Back in 2004, then Assemblymember John Laird introduced legislation to do this. It was not successful at that point in time. I think where we are now is an indication of why we must pass this legislation, and with that, I would respectfully ask for your aye vote.
You'll have to remind Secretary Laird of that.
Backgrounds.
I certainly will.
And the motion is due pass to appropriations. Roll call.
Senators Pavley.
Aye.
Pavley, aye. Stone, Allen, Hertzberg, Hueso, Jackson.
Aye.
Jackson, aye. Monning. Monning, aye. Vidak, Wolk. Wolk, aye.
Aye.
You have 4 votes, and we'll leave it on call. You need 1 more.
Thank you, Madam Chair and members.
All right.
Good job.
So Senator Allen is missing at the moment. So Senator Monning? Yes. Are you ready? File item 14, Senate Bill 1363, Ocean Protection Council,